I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Hey, what's going on, guys? Welcome back to Sovereign Citizens Hall of Fame with your man TP. Today, we are here for compilation number 122. That's right, 122. That is the number that we are on now, and we are in 3 different judges' courtrooms for this compilation. Don't forget to like, share, comment, and subscribe, guys. As long as you guys are engaging and involved in watching, we're going to keep these compilations coming. Now, let me give you the rundown of the judges' courtrooms that we will be in on today for this compilation. First, we will be in the courtroom of Judge Jennifer Grant out of the state of Washington. We will also be in the courtroom of Judge Sam Meyer, also out of the state of Washington. And last but not least, we will be in the courtroom of Judge Tammy Long Hayward out of the state of Georgia. Glad you guys are enjoying these compilations. I'm enjoying putting them together for you. And now let's go ahead and jump into 122.
All right, the Devonte Richard matter 2A04000092 and 2A04000113. Richard, if you could activate your audio and video so I know that you are hearing. Okay, thank you. Wanted to make sure you were participating. Now, is this the case that I believe I saw recently there was a eval set up and they were unable to reach him to participate in that evaluation?
That's my understanding, Your Honor. I saw that as well. I think the last time we were in court, counsel indicated that the meeting had been set up to do the evaluation and the date was discussed. And it looks like Mr. Richard did not appear for that.
And for the record, Sean Parent for Mr. Richard. Yes, unfortunately, that appears to be the case. I'm not sure why Mr. Richard didn't appear at the evaluation.
So, Mr. Richard, we've been waiting for you to talk to one of the doctors, and we've been setting this case over for that to happen. When you were here on April 8th, we discussed that you were scheduled for that appointment on April 24th. So I know that you were aware that they had you calendared. Mr. Richard, why didn't you show up for that appointment?
Well, that was an assumption. I wasn't aware of anything.
Well, you were at the hearing when we talked about it, so.
I don't recall.
You participated on Zoom on April 8th, and we discussed that your evaluation was calendared for the 24th of April.
Was there anything signed for confirmation?
Your attorney has been working to get that set up. So.
Well, I haven't talked to anybody.
Mr. Parent, have you been in contact with Mr. Richard?
Looks like my office, we tried to reach him to make sure that he appeared at the evaluation, but we are unsuccessful in reaching him.
Do you have proof of that?
Yes, I have my colleague's notes that we tried to get a hold of you.
And what was the number?
I'll tell you in just a moment.
Yes.
Mr. Basler, you are excused. Thank you so much for your help this morning.
You're welcome. Bye-bye.
So, Mr. Richard, we have the phone number that ends in 1752.
I'm talking about the number you supposedly contacted the defendant on.
Yeah, you're the defendant, and it's the phone number that ends in 1752.
That's an assumption and presumption. I'm not nobody's defendant. I'm authorized representative of that account.
Okay, so Mr. Richard, the thing is, if you cannot participate out of custody, the court may have to set bail and have you placed in custody to get this evaluation accomplished. So when you are informed of the appointment and then you choose not to appear, the court interprets that as a willful violation.
Under what law are you saying that I could? What charges? What are the charges?
We've gone over that. You have been told that you are charged with driving while license suspended and driving without an ignition interlock device. So I understand you disagree, but at this point, we need to.
I don't disagree with none of the facts. I said, what was the date?
The date of the driving? Is that what you're asking?
Well, I don't drive, so I'm trying to figure out the date you have on file.
June 4th, 2022, Your Honor, is the charge date.
Thank you.
Okay, and have I been charged with anything?
Yes.
And what is it? What are the charges?
As the court just read aloud, driving while license suspended and driving without a functioning ignition interlock.
And is there a witness that you can bring to attain to that?
Those are the criminal charges. You also were cited for not having insurance.
Yeah, but do you have a witness?
Yes, the city has witnesses. We have the officer that will be testifying.
The officer. Okay, well, can you read the police ticket on the record?
We're not having a trial today. We're trying to figure out whether or not you are competent and able to proceed in this matter, and that requires that you speak to a doctor. But that is what we're trying to accomplish. And Mr. Richard, if you refuse.
Can you explain to me? I don't understand. So can you explain to me how
we've explained this to you previously. So what I'm going to ask you is whether or not you are going to comply with meeting the doctor out of jail, or does the court need to set bail and have you booked into custody so they can talk to you there? That's not what I'm wanting to do. I would like you to cooperate and have this case proceed with you out of custody.
Well, I need some type of contract to obtain to whatever you're asking, because I have questions and you're not answering them. Are you willfully not answering any questions?
Your Honor, at this point, I think given the track record of Mr. Richard and his unwillingness to comply, the city is going to be asking that the court set bail and remand him on that bail to have the evaluation done in custody.
Mr. Richard, can you assure the court that you will come to an out of custody evaluation?
I will agree to anything if you guys can tell me the nature and cause of this action. My Sixth Amendment right. I need to know these things before we can move further. Are you refusing to tell me?
I didn't quite hear your question. What are you asking?
I need to know the nature and cause of this action. I need to know that before we can move forward.
Yeah, I believe that the court has told you that you're being charged with driving a license suspended in the 3rd degree and operating a motor vehicle without an ignition interlock device.
Okay, well, I have a question for the judge.
What's that,
Hello?
Mr. Richard?
Hello?
Mr. Richard?
Hello? Or can you hear me?
Yes, I can hear you. You should sit down, and then instead of having me facing you at the clouds, you should participate in this hearing. Thank you. So every time we have a hearing, you ask these same questions, and we've explained to you that you're facing criminal charges and that we need to have the doctor speak to you. And so right now, your option is whether or not, as your attorney said, you can agree to meet with the doctors and stay out of jail to do that, or the court will have to remand you into custody so that they can.
So basically, you're telling me you're refusing to answer me. You're refusing to answer any questions. That's what you're saying? Because I just have questions.
All right, does
Hello?
not. Mr. Richard? We've answered your questions. We're going to proceed at this point. I'm going to.
I
it
didn't
does
even
not-
answer. I didn't even ask the question. So how did you answer it? That's what I'm saying. Are you refusing to answer the questions?
What do you want to know besides what you're charged with? What was your other questions?
My other question was, did you or did you not take an oath to uphold the Constitution? Can I just get a yes or no?
That would be a yes.
So you're enforcing statutes right now, and so you're totally going against your oath. So I'm trying to figure out what authority do you have to tell me to do anything as a public servant? Can you answer that question, please?
Mr. Richard, I am authorized by the revised Code of Washington to sit in this court. I'm duly appointed to be a municipal court judge. I've taken my oath. You're charged with a violation
if you
of
took
the
an oath,
RCW and the Lake
if
Forest
you took
Park
an oath, then
Municipal
why are
Code.
you why are you enforcing statutes if you took an oath to uphold the Constitution?
I know you don't think that it applies to you, but it does. So
I didn't say it didn't apply to me.
I'm
I
going
didn't
to
say it
set
didn't apply to
bail
me.
in this matter at
You're making
$10,000.
assumptions, ma'am. You're making assumptions, ma'am. I never said it didn't apply to me. But we both know here that the Constitution is not for me. It is for the public servants. So I don't know why you're making assumptions and presumptions. All I had was questions, and you're just going around me.
So, Mr.
Obfuscation
Parent,
is
I'm
a
going
big
to
thing
set
now.
bail at $10,000, and we're going to end this hearing, Mr. Richard. You can report to jail. You can come in, but we are trying to do this without you having to be in custody, but you are refusing to cooperate.
I didn't refuse anything. I was never put on notice, so I didn't refuse anything.
Or you
Everything you're
were,
doing
I
right
know
now
you
is
were put
because
on
you want to
notice
do
at
it.
our last hearing, so that's on the record. So
What's
I
on the
know that
record?
to be false, Mr. Richard. So that
So
is the status of this case.
everything that I asked you, am I wrong? Is that
Yes,
what you're saying?
yes, you're wrong. So we're
I'm
going to
wrong.
this, and we are done on this matter. Mr. Parent, if he does reach out to you and something can be arranged for them, but right now the doctors have tried twice to contact you, and you've taken a spot that would have been available to someone else. So we need to progress this matter, and that bail will be set, and we'll continue with an in-custody hearing date when you are booked. A warrant will be issued.
And upon the booking, Your Honor, would the court consider amending the competency evaluation order to reflect in custody, just to kind of expedite that process?
Yes.
For the record, the judge is willingly going against public policy. So on here and in, you're held liable for everything you do from here and on out.
All right. Thank you, Mr. Richard.
For the record.
Can you hear me?
I can. Can you activate your camera?
Yes, just give me a second.
Hi there. So are you, is it Muhammad Idris?
The trustee. I'm the trustee. The trustee of the person is here, and all the beneficiaries have been already named.
Okay, so I'm looking for Muhammad Idris. If you're not him, you're free to go. We'll issue a warrant for him.
I am the trustee of the person.
So, okay, I'm not sure what that means. You're gonna have to explain that to me. I mean, I know what a trustee is. You know, when they have a trustee over as a person, that's someone who governs their affairs if they're not able to manage their own. Generally, people aren't trustees for themselves, and so that's why, you know. And if you're, I'm not sure exactly what that means, and you're gonna have to explain that to me.
What I mean
Like
by
I say,
the
if you're, I mean, I'm sorry.
what I'm saying is the trustee of the person is here, and all the beneficiaries have already been named, and
Who?
it's on a trust, and that trust is private.
Okay, do you have a name?
Because you are claiming that you are the trustee, or the prosecutor is claiming to be the trustee, and the investors
No,
are
I'm
claiming
not.
to be the beneficiaries.
So, okay, I'm going to stop you there for a second because I'm
And
not claiming that. No, you can't finish. When you say you are claiming to be something that I'm not doing, no, I'm not going to say that because that's not true. I'm not claiming to be anything other than the judge in Thurston County District Court who's on this calendar. So I'm not the trustee of anybody.
Well, you're here to come after my personal trust, correct?
No, no. Why would you think that?
I object being a trustor.
Okay, well, you're not one. I'm just trying to find out who you are.
I can't get any clearer when I said the trustee of the person is here.
Okay, is the person here? You're not going to answer that.
The trustee of the person is here.
Okay.
And the beneficiaries have already been named. Is on a trust, and it's private, and my trust is private.
Okay. What's the state's position on where this case is headed? And then I can come back and speak with
Your Honor,
who I assume the trustee of the person is the person named as Muhammad Idris. And so, but let me hear from you what the state's position, these cases look like there's a fraction of failure to control a traffic device. There's a special fuel trip permit. And then there's a failure to comply charge.
Yes.
So what's the state's position on where we're going from here?
If Muhammad Idris is not present, the state would ask for a warrant.
Muhammad Idris I'm going to
to
consider him present based on his verbiage. I know he's operating under a lot of false premises, but that's kind of on him. So,
Right.
but I mean, what is the state where we're at here? If the state wants to go to trial on this case, we'll set it for trial, and then
The state would ask the court to set dates.
Okay.
Within speedy trial, the state also would like to clarify whether Muhammad Idris is intending to go pro se or if he will have counsel at trial.
He looks like he was okay. So I'm going to speak here for just a minute, and I'm going to kind of tell you where we are with this, and then we'll go from there. So, you said a lot of things already that just simply are not correct. And here's where you're at right now. All right. And so you've been charged. There's 3 things at issue here. There's 2 statutes that are alleged to have been violated: violation of a special fuel trip permit, violation of vehicle operator refusing to comply with an officer. And those are both, I think, simple misdemeanors, which carry with them maximum penalties of 90 days in jail and a $1,000 fine. Pleas of not guilty have been entered. And then these cases, they're both criminal cases. And what happens is they either resolve through some sort of plea or some sort of agreement, or they proceed to a jury trial. And now, if it goes to it, since they are criminal cases, it's headed to a jury trial, you're entitled to be represented by an attorney. Look like a previous judge had already ruled that, or found that are you going to represent as the trustee of the person of Muhammad Idris, going to be present to contest the criminal charges against the named Muhammad Idris? Are you going to do that yourself, or do you want to have an attorney appointed to represent? I can screen you for court-appointed counsel, or you can hire an attorney to represent yourself.
Do I have a standing to speak?
Yes.
Okay, I object to what the prosecutor has said.
Okay.
And I'm standing on, I am.
You're standing on what?
The trustee of the person is here, and the beneficiaries have already been named.
Okay.
It's on a trust and it's private.
Okay.
And I object to the prosecutor saying that representing myself, I object to that. I object to being the trustor. And I'm not here to give out gifts, reducing the public law or the public debt. Because I'm brought in as a trustor to give out gifts, and turn around, and what the court is doing is coming after me for the commercial promise. So for that reason, I am the trustee. I'm standing on that position.
All right.
And I'm not here to give out any gifts.
Okay, no one's here for any gifts.
So I object to that. The trustee of the person is here, and all the beneficiaries already been named.
All right.
And I'm not talking about the beneficiaries, which is the investors.
I have no idea what you're talking about. When you talk about the beneficiaries, I don't have a clue as to what you're talking about. So I don't even know what that means. I'm trying to figure out, where we're going to go from here. And I have an idea, but in a minute, I'm going to take up some of these. I'm going to take some of these other cases, and then I'll come back to you. But
I'm the only witness on the case, correct?
No, you're not. That's not correct. No. Give me just a second here. Mr. Newcomb, you can mute up there, Mr. Idris, and then I'll come back to you here in just a minute. And you can go off camera, but don't leave the Zoom call just yet, because this is going to take some time. I'm going to take care of some of these other cases first. Mr. Newcomb, is your case ready? I don't hear him. And then Ms. Lazarek.
Your Honor, we'll be doing a change of plea today, but I'm just waiting for my client to log on.
All right. All right. So you can come back on the, you can come off the Zoom call there. Mr. Idris, you can come back off of mute. You can come back onto the Zoom call. So here's where we're at here. And I started talking about, and again, at this time, I don't want to hear anything about the trustee and the named or unnamed beneficiaries. My only question is, do you want to have an attorney appointed to be involved and help you with this case? I mean, that's a yes or no question.
The trustee of the person is here, and the beneficiaries have been already named. And I'm asking for the court to dismiss this case because I put myself in the position of a trustee.
Okay. The request to dismiss the case will be denied. I'm telling you that. And I'm going to ask my question again. Do you want an attorney appointed to represent you, or are you going to go it alone?
How can somebody represent me when I'm the trustee? Okay. And the beneficiaries have already been named? You can't even continue.
Why do you think that?
What does it have to do with thinking?
Yeah, that's a good question. Well, I mean, you're just telling me that, well, I've named the trustee and the beneficiaries are named who haven't been named to me. So I don't know who they are, and they're really not interested. I mean, if life were that easy, anybody could do that in any criminal charge. Anybody get charged with anything? Well, I'll just name myself the trustee of the person of and name some beneficiaries, then you're off the hook. You know, things just don't work that way.
How come they don't
And
do
so
it?
in terms of, you know, at some point, on the, there was a scene where you were contacted by a law enforcement officer, or maybe even more than one. They identified some charges that, or some statutes you were not complying with, including, you know, the special field trip permit, and you refused to comply with the officers and things of that sort. So they refer that to the prosecutor's office. They're charging a crime. And I've told you what those two crimes are. And now, again, these cases either resolve, and if you've been on the Zoom call, which I think you have for a while, you've seen some of these cases resolve, or they go for a jury trial. And again, you've seen all these other attorneys who represent these folks. I mean, if they could make these cases go away simply by naming someone as a trustee or naming the charged person as a trustee, I mean, shoot, they'd all do it. And then nobody could ever be prosecuted for anything. So that's why I'm wondering why you think that. And now I'm losing my voice, but it'll come back, I promise. So if you're going to keep just
go ahead.
I mean, if you're just going to keep repeating that to me, then I don't have much of a choice other than we'll just set this to a jury trial, and then you can repeat that to the jury and see how that turns out. But I don't really have much of a choice here right now.
I object. Isn't the prosecutor supposed to be speaking and ruling between me and the prosecutor?
Say that again. I didn't understand that. Would you please repeat that?
How come the prosecutor is not saying anything? Why is the prosecutor silent?
Well, because part of my job is trying to identify who's here. And then the prosecutor did say that they want to figure out whether you're either representing yourself or you want an attorney. And so that started the conversation between me and you as to whether or not you want an attorney or not. And I frankly, I still haven't gotten an answer. When I ask you that question, you just go back to restating yourself as the trustee of the person of Mohammed Idris, and then the beneficiaries have been named. So I want to get through that hurdle. And then, you know, I have some responsibility to do some things here before we really hear from the prosecutor. Prosecutor will, I suppose, if this case goes to jury trial, they'll do that. They can negotiate with you some sort of resolution to the problem if you wish to do that. I can set this over for a period of time to give you an opportunity to do that. But and again, you still haven't even admitted that you're the person who was pulled over by the police officers on that day. So, I mean, we kind of have to get through some of these preliminary hurdles before we can get to that.
The trustee of the person is here, and the beneficiaries have already
You have
been
said.
named.
You have said.
You have said. The beneficiaries have already been named.
All right. Do you understand that the prosecutor is an attorney who's passed the bar, practiced law in the state of Washington, appears here fairly regularly, and knows the rules of evidence and criminal procedure, and quite familiar with them, given that that's what their job is?
I object to being the trustor.
Okay. Do you understand what a prosecutor's job is?
I object to being the trustor.
All right, you can go ahead and mute back up. You can stop your camera, and then All right, Mr. Idris, you can come back on the Zoom call, please. Activate your camera. So I'm just going to talk for a few minutes, and then I'm going to tell you what we're going to do here, going from here. It looks to me like your first appearance on these cases was on July 17th, and speedy trial runs through right now, October 15th, 2023. So you are charged, as it looks like you were in front of a pro tem back on July 17th. You're charged, right there, with 2 crimes and there's 1 infraction. Pleas of not guilty will be entered. Anytime anyone's ever charged with a crime, they have a number of rights. You have the right to be represented by an attorney, which I've talked about. You also have the right to go to trial and call witnesses and so forth. And so hang on, just let me finish, please. Don't interrupt me. I know what you're about to say, but I'm going to talk for a while here. So just please don't interrupt me. And at the end of it, then you can say what you're going to say. All right.
My apologies.
So this case has started. This case is headed towards trial, apparently. And if my voice holds out, the trial is going to take place someday before October 15th. You have the right to an attorney. As I said, you also have the right to represent yourself. If you choose to represent yourself, I just want to advise you that you would be at a serious disadvantage. The prosecutor, as I tried to explain earlier, is a trained attorney, been through law school, been practicing law for a while, well-trained, well-versed in the rules of evidence, well-trained, well-versed in the rules of criminal procedure, been through jury trials before, they know how to conduct them. And so if you were to represent yourself, you would be at a huge disadvantage. It would be to your great advantage to have an attorney appointed, or you can hire an attorney to represent you. But as I said before, you do have the right to represent yourself. And normally you go through some sort of conversation with folks. I've been doing this job for a number of years now. I've had several people represent themselves. Normally there's a conversation I've had with people about asking them that they're aware that if they represent themselves, they'd be at a disadvantage. I tried to engage in that discussion with you. You just kind of reverted back to repeating that you're the trustee of the person and the beneficiaries and the name, so forth. But rather than go through the question and answer portion, I'm just going to tell you that's where we're at. So we're going to set this case. We're going to do 2 things here today. We're going to set the case for trial. You're going to get notice in the mail of that. You're also going to I'm going to set a status hearing or a pretrial hearing in about 3 weeks. And then somebody else, maybe it'll be me, will probably try and go through all this again. But I'm going to tell you some things that, you said you object to this and you object to that, and you're free to object to anything you want. But I have the ability to either overrule the objection, which means, turn down your objection or sustain your objection. And I'm having trouble actually understanding what your objections are. And so, and again, I'm going to lay out some of what's going to happen at trial if it goes that far. In a trial, they have a group of citizens come in, both the attorney and defense attorney or the person represent themselves, and the prosecutor has an opportunity to question them, talk about the issues that might come up in the case. Then they can eliminate who they don't want on the jury. And then 6, you will end up on a jury, and then the state will present their case. You or an attorney, or you on your own behalf, or you as the trustee of the person, can present your case or explain to the jury why you think you should be found not guilty of what you're charged with. And so in the grand scheme of things, frankly, the charges that you're charged with are not far from the most serious that we see around here. They're not. But they are crimes, and they are in their own way serious. And so I don't know whether anything I've said has made any impression on you at all, but that's what's going to happen here today. And if you wished so this case is headed for trial, and like I say, we'll do sometime before October 15th, but we're going to do a intervening, and I'll tell you when that is. Why don't you set just a status pretrial for like about 3 weeks. And you can think about what's going on here. You can think if you want to take some alternative place. If you want to just come to court and keep repeating the same thing to me when you get in front of a jury, you keep repeating that same thing to somebody else, you know, that's, I suppose there's no way I can stop you of doing that, but I'm just trying to enlighten you on what's going to happen. And, you know, some of, you know, your objections you talk about, see, that's the advantage the attorneys have. The attorneys know when objections are well-founded and when they're not. And I kind of get the sense from you that you really don't have a complete or accurate idea of what this is all about and what's happening. And so I tried to spend some time explaining that to you as best I could. And I guess I told you I'd let you speak, or hinted that I would let you speak. I'll go ahead and tell you. Do you have any response or any thoughts on this, or would you understand this is going to trial, or go ahead? I've said what I'm going to say. I'll turn things over to you. Any response to any of that?
Again, I object. I'm standing at what I said.
Okay. And what specifically do you object to? Just so I can create a record, so I'll make a ruling on your objection. What are you objecting to?
I'm objecting to everything you're saying. It's a hearsay. It's a assumption, a presumption. It's a tacit agreement. It has nothing to do with the facts. That's why I'm the trustee. It has it has everything to do with the trust law. The trustee of the person is here, and the beneficiaries have already been named. That's why I have a trust, and my trust is private, and I don't see your trust. And in the trust that you have, the trust that the prosecutor has named you as the trustee. That's why you keep asking the prosecutor what they want to do, because they named you the trustee. And you guys brought me into court to bear gift, to give out gifts. And I'm not here to give out any gifts.
Right.
I'm here to object to giving out any gifts that's supposed to reduce the public debt. Am I wrong?
Yes. Yes, you are. And that's frankly, that's kind of the sad thing, because I'm really not sure completely of what you're saying, but a lot of the things you just said are quite simply not true. And I asked the prosecutor where they wanted to go in the case, because they file the cases, they choose to go forward. Sometimes, as you've seen today, if you've been paying attention, the prosecutor said, "No, Your Honor, we're going to dismiss this thing." And so I dismiss it. So I asked the prosecutor, they filed the case. What do you want to do with this case? They said they want to go forward, which brought about this conversation that we've been having. And that's just one example of one of the things you're wrong about in terms of this whole trustee thing. I don't know what that means to you, but I have an idea of what a trustee and is and things of that sort. And I don't have a trust. I'm not anybody's trustor or trustee. In this court, neither is the prosecutor. And so when you say, am I wrong? You know, the short answer to that is yeah. And unfortunately, and I'm taking some time to try and explain it to you, but I just don't feel like I'm breaking through. But to answer your question, am I wrong? Yes, you're wrong about a number of things, which is really unfortunate that I can't explain that to you or make that clear to you.
What's your evidence? Evidence is clarity.
I'm sorry?
What's your evidence that I'm wrong?
Well, I mean, you know, other than me just telling you that I'm not a trustee, I can't prove something doesn't exist. I mean, there is no trust. There's nothing else. And I have no documents that saying there's not one, and I don't have any there is no document saying that there is one. And so again, that's on that single issue. That's.
So you're not coming after my personal trust?
No.
So personal
again,
trust
I'm not sure.
Exist?
Well, let me rephrase. I'm not sure what that means. Again, you're charged with a crime. That crime needs to be resolved, or either through trial or resolution of some kind. And so in terms of coming after your personal trust, and by the way, I'm not the one who filed the charges. That was done by the prosecutor and all of that. And so what they're trying to do, I think, and I don't know this for sure, and I'm just trying to do this by way of explanation, not because I'm on anyone's side. It's their responsibility. They're bringing the charge. It's their responsibility to prove it beyond a reasonable doubt. It's your or the defense attorney's role to explain why the charge should never have been brought, or that there reasonable doubt exists as the charge was ever committed. That's what this is about. This whole trust thing, I think you're just going down a way that's really doesn't have any relevance to what's happening here. And I've tried to explain that to you, and I'm more than willing to continue we can't go at it all afternoon, but I'm trying to make this as clear as I can to you. But again, it's unfortunate. It's a failing on my part that I'm not able to break through to you.
Your Honor, if I might for a moment.
In a minute. So I guess we'll set it for status hearing. We'll set trial dates, and then we'll just go from there.
Your Honor, based on this conversation, the state has concerns about the defendant's competency.
Yeah, we're not going to go down that route right now. And so you can raise that, but I'm not denying that without prejudice. But at this time, we're not. For one thing, as you well know, given the nature of the charges and given the schedule, this case will drag everything on we'll be here for the next couple of years. And at this point, I'm not prepared to do that. So you can bring this up again if you wish, but for right now, we're not going to go there. And do you understand what the state just said to me and what I turned them down for? Again, that's a yes or no question. The representative from the state, the prosecutor, she just said something to me. And I said, no, we're not doing that now. She made a request of me. And so do you know what that request was?
I am the trustee, and the beneficiaries have been already named. So,
all right. Did he been sent discovery?
No, Your Honor.
Okay.
Because
Yeah, I understand why. I understand why. All right, so what's 3 weeks? What's 3 weeks from today? When's the trial date?
September 13th.
We're going to reset this to September 13th. Put it at the end of the calendar.
Okay.
What time?
2:30.
At 2:30. That'll be your next court date. You're free to go.
All right, thank you to everybody who's been patient for the 11 o'clock calendar. I'm gonna go ahead and call that calendar and we'll get you sorted as quickly as possible. First case on the 11 o'clock calendar for the civil calendar for Judge Tammy Long Hayward, State Court of Clayton County, December 3rd of 2025 is Wells Fargo Bank versus Ilan Bomani. Wells Fargo Bank versus Ilan Bomani.
Hello, Your Honor. This is Prash Maharaj for the plaintiff on that matter.
All right. I'm sorry. Who is it? Oh, Mr. Thank you. I'm trying to pin everybody as I hear them. That makes it a little easier to see who's talking. All right. And Ms. Bomani, I see.
Yes, I'm right here, Ilan Bomani.
Yes, ma'am. All right, Ms. Bomani, do you have somebody representing you or are you representing yourself?
I'm representing myself today, Your Honor.
All right, so all right, so this is a contract with respect to what appears to be like a credit card or some kind of credit account. Is that correct, sir?
Yes, Your Honor.
Okay, and the defendant was personally served and answered filed a counterclaim.
The answer does say counterclaim. However, I didn't. I've got it pulled up right in front of me. I had a chance to review it, and it doesn't. I don't see really where any claims against our client have been made.
Yeah, I think that was that she was seeking information that she says wasn't provided.
Okay.
But I don't know that it was a counterclaim in the true sense.
Yeah, that's what I was getting at.
Okay, so go ahead, sir, and present on behalf of your client. And is your client the original creditor?
Yes, Your Honor.
Okay, so ma'am, this Mr. I'm sorry, Mr. Maharaj?
Yes, Your Honor. You got
Okay,
it.
Mr. Maharaj represents the original creditor, Wells Fargo, and go ahead, sir, and present.
Yes, Your Honor. If it may please the court, yes, this is I will be brief on this one, Your Honor.
No
This
problem.
is a lawsuit brought over a consumer credit card agreement entered into between Wells Fargo Bank and Elon Bomani. The facts of this case are fairly simple, as stated in our motion.
Do you have what they're seeking? What was owed?
I'm sorry, say that again, Your Honor?
Do you have what was owed? What are you seeking?
Yeah, we are seeking principal amount of $16,217.20, court costs of $307.11, and this particular client, when it comes to collecting attorney's fees, they ask that they don't collect any attorney's fees over if it turns out to be over $800 or more, they don't collect more than $800. So in this particular case, the actual motion says attorney's fees of 15% of the first 500 and 10% of the remaining balance. If that turns out to be over $800, the client has asked that it be capped at $800.
Okay, I got it. No problem. All right, so Ms. Bomani, my review of the information shows that there's not really a cognizable defense in that there's no defense that you do not owe the debt. And the counterclaim seems to be that you were seeking documents.
Yes.
Okay.
The affirmative, the response, the affirmative defense is that the plaintiff did not provide documents showing a contract between the defendant and Wells Fargo Bank with the defendant's wet signature. The second one, the plaintiff has not provided any documents authorizing the handling of the defendant's personal data. This is all information I requested. Number three, the plaintiff has not provided a complete account number for defendant to review for the alleged debt. Number four, the plaintiff has not provided a full accounting of alleged debt for the amount of $16,217.20. Account numbers unknown. Defendant requests to review all original creditors, payments, credits, interest rates, disputes, including a signature or digital PIN code approving alleged charges claimed. Number five, plaintiff has not provided any documentation showing the debt is 100% accurate with no errors or omissions. Number six, the plaintiff has not provided communication between the plaintiff and the defendant. Number seven, the original creditor has possibly filed a 1099-C collections of debt with the IRS. This would void any ability to collect on any alleged debt. Defendant requests proof Wells Fargo Bank have not filed a 1099-C collections of debt write-off to the IRS. Number eight, the plaintiff did not provide a dunning letter giving defendant the opportunity to dispute alleged debt. Number nine, the plaintiff has excessively delayed in bringing this lawsuit to my disadvantage due to non-availability of communication and document requests being cut off with the original creditor to establish concrete proof of the claim amount by the plaintiff. Number 10, the plaintiff attorney, I don't want to mispronounce your name, sir, so excuse me if I do. Paresh Maharaj of Lefkoff, Rubin, Gleason, Russo, and Smith, PC, is a debt collector, has a requirement according to the Fair Debt Collections Practice Act to notify defendant by mail with a dunning letter, giving the defendant the opportunity to dispute alleged debt. Number 11, the plaintiff attorney, I've already spoke of their names, is a debt collector and has requirements according to the Fair Debt Collection Practice Act, 15 USC 1692G, to review and provide documentation to show proof of alleged debt and how plaintiff provided proof of how the alleged debt was accumulated with true accounting records and statements. And last, number 12, the plaintiff attorney is a debt collector, has a requirement according to the Fair Debt Collection Practice Act, 15 USC 1692G, to provide a proper validation of debt within 5 days of initial contact. Because plaintiff attorney never provided a dunning letter to the defendant, plaintiff attorney did not comply with the FDCPA requirements, 15 USC 1692G. Defendant reserves the right to amend his answer after receipt of additional documentation from the plaintiff. And this is what I had requested.
All right, Mr. Maharaj, you want to respond to any of that?
Yes, just again, as mentioned in our response to the opposition to motion for summary judgment. Hang on, let me find it. That was a lot. I especially want to highlight the claim that plaintiff has not provided a verification of the debt and all of the accusations that the debt has not been properly verified under the Fair Debt Collections Act. Although not required by statute, we did provide verification of the amount owed to the defendant on April 29th, 2025. This verification was mailed to the defendant to an address of 11383 Michelle Way, Hampton, Georgia, 30228. This was attached as Exhibit A to our response to the counterclaim. Furthermore, we have judging from the exhibits that we have provided with our original complaint, which includes bank statements and payment histories that have been authenticated by affidavit, we have provided accounting showing the balance owed. So I would just say that we have met our burden to verify this debt, and we have upheld our burdens under the Fair Debt Collection Practices Act, and as such, there is no issue of material fact, and ask that summary judgment be granted.
So Ms. Bomani, he stated that on April 29, 2025, the quote-unquote dunning letter that you requested was sent to the address, that there are bank statements filed with the court that show the progression of payments and their accounting with respect to the amount owed.
I'm sorry. I didn't hear the first part of it.
The quote unquote dunning letter that you wanted.
Yes.
Was sent on April 29th of 2025, and that the file contains the accounting complete with bank records to show any payments made to the account.
That I did not receive that, ma'am.
Did you look at the clerk's file?
The clerk's file?
And he would have filed it with the court clerk.
Yeah, I did not see that. Not at all. Where shows proof of that? Because even in my defendant motion of opposition to plaintiff for summary judgment, it basically stated that I have not seen that, ma'am.
Okay, Mr. Maharaj, you filed all those things with the clerk of court?
Yes, State Court of Clayton County. This particular one was filed on September 22nd, 2025.
That was after.
After what?
After I made the request for it. I made the request for it on July 17th of 2025.
Yes, and the
So in response to your request, he filed it with the court clerk.
Okay, I didn't receive any information in regards to
Did
that.
you send Ms. Bomani a copy under by post, or did you just electronically file it?
This was electronically filed.
Okay. I'm not sure if she gets the electronic filings.
I did not.
We also filed a certificate. There was a certificate of service. It was with the same mailing address that we had, 11383 Michelle Way, Hampton, Georgia.
Okay, so you did send it separately?
Yes.
All right, so he said he sent what he filed separately to you.
Ma'am, I in all honesty, Judge, Your Honor, I never received it.
All right,
I'm just now finding out about it today.
Ms. Powell?
Yes, ma'am.
Do you see the documents filed by Mr. Maharaj?
I have seen them. I can pull them up again, but I do specifically remember looking at them and looking at the date of April 29th. It was filed into the record, but it was proof that he had mailed it previously.
Okay. All right, so if you want to put, you can put those up. Ms. Powell, let me see the file.
Okay, just give me 1 second.
Mm-hmm.
Your Honor, if it would help, I have it pulled up. I could share my screen.
Yeah, go ahead, Mr. Maharaj.
Okay. Okay, is this working?
Yeah, that's fine.
Okay,
so this is the certificate of service, Ms. Bomani?
Yes, ma'am.
Okay. Go ahead, sir.
And yes, so as you can see, a plaintiff's motion for summary judgment in response to counterclaim. And this is just to go from beginning. Here's the proposed order. Just to this is the first page of the actual motion. As you can see, you filed on that date. Just gonna scroll through just to show everything. And here's
I did receive that, yes, but I did not see it in compliance with the Dunning.
Well, again, as attached as Exhibit A, here's the letter right here that was mailed on April 29th.
And that's what I was also going to pull up, Judge. There's no that I saw no fuller copy of the letter, but it is verification that the plaintiff or the defendant's requests were responded to.
So, ma'am, this is what you were asking for.
Okay. All right. Okay. I did receive that.
Okay, so then he did comply with the regulations that you stated.
Okay.
Is there any dispute that you have as to the amount of the debt of $16,207.20?
Yes, ma'am. Like I mentioned to you, in my defendant motion in opposition to plaintiff's motion for summary judgment, the key thing that I requested was that the plaintiff.
Do you have evidence of payments made?
Yes, Your Honor. They are included with the original complaint, and labeled as exhibits A, B, and C. I could also pull those up. Oh, would you like me to pull those up?
You may. Ms. Bomani, do your records differ from the records Mr. Maharaj is presenting?
The key thing that I wanted to establish was that the plaintiff motion, it's vague, it's not conclusive, it's not including all the other information that I had requested.
So, okay, do you have any information that says you made payments that weren't taken into account?
No, ma'am.
Okay, then that's what I'm asking. So at this point, the court is going to grant the amount of $16,217.20 plus $307 in court costs, $307.11 in court costs, plus $800 in attorney's fees as capped by the contract. All right, Mr. Mirage, you've presented a proposed order. The court will get that signed. Ms. Bomani will get you a copy of the proposed judgment. Of the judgment, and then you, if you wish to speak with Mr. Maharaj, to, I guess, request a payment plan with his client, I'm sure he'd be willing to talk to you about that.
Honestly, we have a negotiations team. I could have them reach out to you. Is your email address, Ms. Bomani, still elon.bomani@gmail.com?
Yes.
And phone number is still 470-771-0401?
Yes, that is correct.
Okay. Well, as long as we have correct contact information, we can reach out to you.
All right, thank you.
Thank you. And that's the only matter I had, Your Honor, if I may be excused.
You may.
Thank
You're
you.
free to go at this time.
Your Honor?
Yes, ma'am.
I would prefer for us to go through it's possible that we could go through, I don't understand why, since they didn't provide all the information that I requested, that we could not consider going to trial. I'm trying to understand.
Ma'am, this is the trial.
I was told it was an oral here, that it was an oral.
He's asked, this cuts off the trial because he's gotten summary judgment.
But I responded to the summary judgment.
I got you, ma'am, but I'm not ruling in your favor. I'm ruling in favor of Mr. Maharaj. You haven't presented any information that would suggest that there's any reason why the court can't find in favor of Mr. Maharaj, because you haven't presented a genuine issue of fact for determination by a jury. You kept asking them for information, but you've never countered the information that they presented. When I asked you if you had any different information about payments made, you said no. All right, so you can work that out with Mr. Maharaj's client with respect to payment. Okay. All right, the next case is Jennifer Clifton versus Chaz.
I'm not threatening you. Say one more word and that's 30 days. 30 days.